Hey everyone! Welcome to today's video. Today, we've got 5 different sovereign citizens in 5 different courtrooms. We have 3 returning sovereign citizens with several updates to cases I've already covered, an actual American national who thinks laws don't apply to him, and a Karen who refuses to participate in her custody hearing. At the expense of her children, we've got a lot to cover today, but before we dive in, I want to thank today's sponsor, Aura. Did you know that AT&T recently revealed that over 73 million current and former users' account data was leaked?
Pardon?
Yes, I guess I'll represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
All right, that's the first sovereign citizen out of the way. Basically, he negotiated himself a sweet plea deal, never showed up for probation, so it got revoked, and now he could be facing jail time. Next up, we head to a hearing involving one of the most obnoxious sovereign citizens I've ever covered, Albert Hicks.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's to advise you of why you're here,
Oh, okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the. We'll file it. File.
Yeah. But I'm not going to sign anything though. I'm not going to sign anything.
Well,
yeah.
I don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
Yeah. I don't.
When is the last time that you worked?
About a year ago, maybe a little over a year ago.
All right. How old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
a little over a year ago.
Okay, so I'm going to go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll be around and be available for you. Okay.
Yes, ma'am. I'll take counsel, no doubt.
All right. Thank you, sir.
Okay, thank you.
No, you don't. You have a constitutionally protected right to a jury trial, not a right to choose between a jury trial or a bench trial. An actual attorney would know this. Now, we're heading to the end of Judge Perkins' docket, where Mr. Hicks is about to reach the conclusion on these charges, and I mean just these charges.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr. Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
So, I know a lot of you aren't going to be happy with this outcome, but hear me out. I don't personally mind living in a system that requires this level of scrutiny for a guilty conviction. In my opinion, a few guilty people slipping through the cracks is far better for society than locking up innocent people for nothing. But, if you know anything about me, you know I'm not going to leave you hanging. I've got this clip from Judge King's courtroom, where Albert Hicks is facing a domestic violence case involving his long-term partner, the mother of his 2 children. Pay close attention to his face as she testifies at the probable cause hearing.
You're your own attorney. You're an attorney registered by the state of Michigan.
You don't have license to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date, or you want the offer to send it back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're a grown man.
Jurisdiction is something that's both established and proven. It's established by Michigan statute and proven by a preponderance of the evidence at your trial if you're challenging the court's jurisdiction based on facts like time, date, or location. You need to provide evidence to support that claim.
Let's have a few seconds. Wait a minute. Let's have a few second conversation, okay? Now let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime. no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. Give me a minute. You even went through a 10-3 because you started threatening me. You remember that?
No, you were the one, wait a minute, you were the one, Mr. Hicks, that said, oh, you can say all that while you're on the bench. That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything here. That's all public
information. You're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks.
Let's
not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes, I did.
I thought about that.
I don't even have a
I
license
thought
to
about that.
law.
Listen, this whole
have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have a right to either or. You're not the one.
No, you don't have a right. No, you don't have a right to either or.
Yes, I do. Of course I do.